Okay, on the record in the matter of the state of Michigan versus Jeffrey Smith. 25-01341, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. I would like to make a motion to practice under Michigan Code 8.120.
Motion is granted.
Thank you, Your Honor.
Morning, Your Honor. Attorney Derek Estes, also Public Defender, on behalf of Mr. Smith. Mr. Smith is appearing from Union County Jail by video.
Okay, today was the date scheduled for a probable cause conference. This matter is scheduled for preliminary examination on May 22nd at 8:30. My understanding is that there is a request to waive the timeline.
Yes, Your Honor. At this time, we're asking the court to accept the timeline waiver. Your Honor, we're working on a global resolution. Currently, the plea offer would be to plead to domestic violence and file 25-1214 SM, as well as the OWI in the felony file. The other counts and the habitual would be dismissed as part of the plea agreement. We're asking the matter be set out past the domestic violence case's court date so that Mr. Smith can talk to Mr. Riley and they can make a determination on what they want to do in the domestic violence case. But that's the purpose at this point, is to continue negotiations to work out a global resolution.
Oh, and Mr. Smith, can you hear me?
Yes, I can.
Okay, so you understand that you have the right in the felony matter to have a preliminary examination within 21 days of the date that you were arraigned?
Yes.
Are you willing to waive the 21-day timeline so that this can be reset while they work through a global resolution of your files?
Yes.
Is anyone threatening you to do that?
No, ma'am.
May 30th at 9:30 work?
Yes, Your Honor.
Okay, we'll reset this till May 30th at 9:30. Mr. Smith, do you have any questions?
No, ma'am.
Okay, any additional matters for the record, counsel?
Not on behalf of the people, Your Honor.
No, on behalf of the defense, Your Honor.
Thank you, you're all set.
Thank you, Your Honor.
Okay, on the record in the matter of the state of Michigan versus Harvey Edwards, 25-00552, appearances, please.
I'm free to
Your
go.
Honor,
Yes, you are free to go.
Haley Fortuna Gill on behalf of the people, Your Honor.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Harvey Edwards, who is present and joins us on Zoom.
Okay, Mr. Edwards, can you hear us?
Yes.
Okay, today was the date that was scheduled. For sentencing. I do have a pre-sentence report here that was prepared on the 23rd of April. Counsel, did you get a copy of this report?
Yes, I did. We did, Your Honor. Or he says to the defense, and I have shared a copy and had it reviewed with Mr. Edwards. No additions or corrections. Other than I think there would be a different custody amount of time.
Okay. No need to make any updates or corrections, correct?
Other than I think the jail credit, but this was an adjourned sentence, and there was a problem the last time, apparently.
Correct. Okay, you can address the court.
Thank you, Your Honor. Mr. Edwards, as noted in the PSI, has been in custody since February 18th of this year. While as noted in the pre-sentence report, he has some differences in how things occur, but I don't think there's any difference in the opinion that he has, as well as I think probation has, that this could have been handled differently and should have been handled differently. He does have a guardian. He has been taking advantage of programming while in the jail. I'd ask the court this time to allow him the chance to have a term of probation. And I think he indicated he's been successful previously on probation. And I have no reason to think he could not do that. I think with some additional supports from the court and reconnecting with outside with community mental health as well as his guardian, I think he should be able to be a successful candidate on probation. So I'd ask the court to consider that. Thank you.
Did your client want to make a statement at all?
I am not sure. Mr. Edwards, would you like to say anything to the court regarding your sentencing?
What's that?
Would you like to make a statement to the court regarding your sentencing here today?
No.
Okay, I've reviewed the pre-sentence report and the recommendation as well as the prior criminal history of the defendant. I think a term of probation with some programming is appropriate. And as such, the court will adopt the recommendation. The defendant will be placed on a term of 10 months probation. While on probation, sir, you have the following conditions. I am going to order that you engage and continue engagement at community mental health.
Ooh.
I'm going to order that you complete the moral recognition therapy program. Also, I'm going to order that you obtain employment and provide evidence of that to your probation officer. Do you have any questions so far? Do you have any questions?
No. No.
Okay, also while out on probation, you're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You're not to engage in any assaultive behavior or any threatening behavior. Do you have any questions about that?
No.
You cannot possess a firearm, you cannot possess a weapon of any kind, you cannot possess any ammunition. You are not to be at any bars or nightclubs, and you will be required to submit to random preliminary breath testing and urinalysis testing. You have to pay the cost for that, okay?
Okay. Yes.
Okay, there's a $30 per month oversight fee that will be assessed plus a $50 state minimum cost that, I'm sorry, $30 per month oversight fee that will be assessed for each month. So that's $300. There's a $50 state minimum cost that will be assessed for $75 crime victim rights fee that will be assessed. I'll waive discretionary fines and costs. However, this was, I believe, 2 counts. What's happening? Okay, pled guilty to 2 counts of police officer or attempted police officer assault, resistive shot, correct?
That is correct, Your Honor.
Okay, let's see. So there will be a $50 state minimum cost per account that's going to be assessed on this file. Looks like he has credit. Well, I'll give him credit for the 74 days. However, if you're not successful on probation, you will continue to serve the remainder 365 days maximum penalty on this. You understand that?
Yes.
Do you have any questions at this time about your probation terms or fines and costs on that file? What's the question?
Oh, no, I ain't got no question.
Okay. I also have file 23-025970M. That was a trespass that you accepted responsibility to breach of peace. I think it gave you a fine of $50. It was set for today to determine when he's going to be able to pay. Is he only being held on this, or is there something else?
This is the only thing holding him at this time, Your Honor.
Oh. And he received Social Security.
Yes, Your Honor.
Okay, Mr. Edwards, you need to pay the $50 on the breach of the peace file 23-02597 within 30 days of your release. Okay,
I'll give you that.
excuse me?
Yes, I'll give you that.
I don't know what he's saying.
Can you repeat that one more
Yes,
time?
Yes, I'm gonna give you that.
Okay, okay, once you're released, you need to report in person to probation so that they can get you squared away with the judgment of sentence. Give me your address again.
902 Seymour, apartment 5.
Apartment 5,
Yes.
what's your phone number?
That's the thing. I don't know. I don't have no cell phone. As soon as I touch out there, I was gonna give you the cell phone.
Okay, you'll check in with probation. You will be able to meet via Zoom for your probation monthly meetings, but if you don't have a cell phone, you're probably gonna have to meet in person, okay?
Okay. I'll be down there. For sure.
Any additional matters for the record?
No, Your Honor. Thank you.
You're all set, sir.
Okay, thank you. We can talk.
He's gonna be released today. Would he be released today, Your Honor, then?
He should be released today. He needs to check in by Monday with
Okay, thank you.
probation.
Yeah. That's okay.
Okay, on the record in the matter of the state of Michigan versus Davin Anderson, 25-01067.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Anderson.
Ms. Anderson was scheduled today for a preliminary examination. Are we running the exam?
This is going to be a no contest plea, Judge.
Are you preparing the paperwork? Is that what's going on?
Yes,
I'm preparing the plea sheet.
Sounds good. And he has an advice and rights.
I'm filling that out right now.
Okay, very good. I'll call the next case. I
Sure.
think we have an interpreter. Well, we don't have the AG here, do we? We do. Okay, on the record in the matter of the, well, Ms. Schroeder's still here. On the record in the matter of the state of Michigan versus Lariano Shabeco, 18-00440.
Attorney Christy Berta from the Attorney General's Office for the People, Your Honor.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Shabeko. I don't know if we have an interpreter yet for him. I did want to speak briefly with him again, if possible. I think it's scheduled for 9:30.
We don't have an interpreter yet.
Not yet.
Okay, we'll call the case for the interpreter. You have to wait for the interpreter. I thought that was the interpreter sitting in the back. Who was that sitting?
He is here for the Micah Arnold case.
Here in what capacity?
He said he was told by the prosecutors.
He's a witness. Did you find out what his name was?
By the prosecution.
He's got a clergy badge.
Okay.
He's got a clergy badge. What? Just saying. Okay, the interpreter is here on Shabeko.
Yes, Your
Okay, yes, we're gonna put you in the breakout room with the attorney and the defendant. Elections must have been busy.
I guess it's my turn, that's true. We'll stop no longer here.
Oh, boy.
Right.
That's right.
This is getting deep.
We did lose.
Ms. Schroeder, are you ready? Ms. Schroeder, you ready?
Yes, sure.
Okay. Okay, back on the record in the matter of the state of Michigan versus Lariano Shabaco, 18-00440. Appearance, please.
Christy Berta from the Attorney General's Office for the People.
And thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Shadeko, who appears from the Ingham County Jail.
Thank you, and we do have an interpreter here, is Jorge Defberto. Can you
Yes,
raise
Your
your right hand? Please? Do you solemnly swear or affirm to interpret in the matter completely and accurately and not divulge confidential communication, so help you God?
I swear.
Okay, today was the date and the time that was reset for a probable cause conference on this. Let's see. I have a note in here. This is right.
Se hace la presentación del caso. Estamos en fecha y hora del caso presentado. Se presentan ambas partes y ahora vamos a comenzar.
I was gonna say, Judge Luca put a very robust note here as to the last proceeding about the offer and the amount of arrearage. How are we proceeding at this time?
Thank you, Your Honor. At this time, after speaking multiple times to Mr. Shadeko, it's my understanding he wants to have this left set for preliminary exam. I will continue talking with him.
Gracias, señoría. En este momento, luego de revisar el caso, vamos a asignar que el señor Chabeco acepta a seguir la examinación preliminar para la próxima semana.
Okay, the exam is scheduled for May 22nd at 9:30 in person at the court.
La examinación preliminar está para el 22 de mayo a las 9:30 de la mañana y va a ser presente a la corte.
I need to remind counsel that all offers will be revoked if the matter proceeds to prelim.
Debo informar en este caso a tu abogado de que cualquier otra oferta que exista en este momento va a ser revocada si seguimos a lo que es la examinación preliminar.
I may, Your Honor.
Yes.
I have made Mr. Shadeko aware of that multiple times, just so the record reflects that at this time, he is still requesting the preliminary exam, but again, we will continue the conversation. If I could address, I know that the bond.
He's
Sorry.
gonna interpret.
Yes.
La defensa en este caso sabe que cualquier oferta puede ser revocada en caso de seguir a la examinación preliminar y que se ha hablado contigo directamente y hasta ahora tú aceptas o has pedido continuar ahora al siguiente plazo que sería la examinación preliminar.
Okay, you wanted to address bond.
I would, Your Honor. I do realize that on child support cases, bond is generally set by the statute.
Van a pedir que haga un punto de un bond y sabemos que en los casos de child support, en este caso, pues está puesto según lo que le dicta la ley.
However, I do note that there is a potential way for good cause to adjust bond. Mr. Shadeko cannot work. He is unable to make any payments toward anything at this time as being in the Ingham County Jail as he has been. I would ask the court to consider, because he has been in custody for some time now, and he has no way to make payments. This is a nonviolent offense. If anybody wants any money, he needs to be able to work. And you can't do that from jail. I'd ask the court to consider maybe lowering his bond. Thank you.
Just so I'm clear, the good cause is because he's in jail and can't get to work?
Yes. He has no way to make payments on any of this.
I don't think that when the drafters of the legislation indicated that an individual shall remain in custody unless the court finds good cause, that they were taking into consideration that being in custody would present the good cause. Obviously, you can't go to work if you're in jail. That doesn't amount to good cause. So your motion's denied.
Thank you, Your Honor.
Any
O sea,
additional
en este
matters?
momento,
No, Your Honor.
en este momento la defensa pedía ajustar o sea, el costo para libertad condicional, o sea, el punto de bond, para poder, porque estás en la cárcel, no estás trabajando, so no hay una forma de hacer ningún pago respecto a eso. En este caso, la jueza dice que directamente en el momento que se escribió la ley no especificaba por qué era que estuvieras en cárcel o no. Por tanto, esa moción que pide tu abogada está denegada.
Any additional matters from the AG?
No, Your Honor, thank you.
Okay, you're all set for today.
Thank you, Your Honor.
Ya está todo listo para hoy y seguimos para las próximas semanas en la continuación del caso.
Ms. Schroeder, I have an email about your other matter if you wanted to waive your, Mr. Shaveco and Mr. DeFerno, you're free to go. Thank you.
Oh.
Ya hemos concluido por hoy y vamos a entonces continuar la semana siguiente. Gracias. Thank you, Your Honor.
Thank you. If you wanted to waive Ferris Schneider's appearance, we can do that today. Okay, on the record in the matter of the state of Michigan versus Ferris Schneider, that's 25-01090 FD appearance.
Sorry, Your Honor, can you?
25-01090 FD.
It's a matter for tomorrow that we wanted to address.
That makes sense. Okay. Haley Fortuna Gill on behalf of the people, Your Honor.
And thank you, Your Honor, Assistant Public Defender Aaron Schroeder, on behalf of Ms. Schneider, who is not here. I'd ask the court this time to waive her appearance based on the email communications I've had with the court this week.
Thank you. And the court will grant the waiver. My understanding is that your client is currently housed in a hospital facility for behavioral health. Is that correct?
That is correct, Your Honor. She is still there as of yesterday, and I believe she'll have a projected out date fairly soon, but my understanding is they're looking to send her to inpatient recovery and treatment as well. We are currently set for a preliminary exam tomorrow. I'd ask the court to find good cause to waive the timeline so that she can complete her treatment.
Okay, the court finds good cause based on the information provided about Ms. Schneider's condition to adjourn the matter and reset this at a time when she can appear in person. June 27th at 9. June 27th at, you said 9? Yes. At 9.
I will relay this to her. I don't believe that will present an issue. I will let the court know if there is any other issues.
Any additional matters for the record?
On behalf of the people, Your Honor.
Just to confirm, June 27th at 9 a.m.
That's correct.
Thank you. Nothing further.
Thank you. Let's see, Mr. Sarts. I have it that they were leaving Taylor on, correct? Mr. Sarts?
Yeah, that's correct, Your Honor.
Okay.
He appeared this morning and I was able to tell that we're just gonna leave it on and have it back here next week. Thank you.
Very good. Okay, and then of course, it's 9:48 and we've not seen Mr. Courtroom. Correct?
Correct.
What in the world? Jaywalking? Tickets? Who gave the person a jaywalking ticket? Who did it? Now it's $180 for jaywalking. Unable to show cause to defendant because the defendant is homeless. Homeless shelter address on ticket unable to locate. It's a stupid ticket. Close file. Who's giving out jaywalkers? I want to know. Right, Riedel did that.
He spoke to me about that case. I'm not sure. I believe that he was gonna talk to his client and get back to me, so I'm not sure, maybe that's.
Well, his client should have been here. His client is in high school,
He's only 18.
might be at school. You know, Mr. Etheridge went.
No, I haven't done
You need to know if he spoke, is Mr. Walker here?
it before. Has not checked in with me.
What's your name, sir?
Yes, yes. That's right.
I don't like this. I want to do something from the service.
This is the one to director, us sincere, so.
Survive.
Yes.
That was my goal.
Exactly.
I wasn't trying to cut throat. I wasn't trying to get that off my.
Fair.
I wasn't trying to sort of out of that.
Yeah. Right.
Are we ready on this matter?
Yeah.
Okay, Mr. Anderson is scheduled today for preliminary examination I do have a plea sheet. It says the defendant is being offered a no contest plea, correct?
Correct.
Entry without permission, dismissed remaining upon successful plea. Is that accurate?
That's correct, Your Honor.
It is.
What is the purpose of the no contest plea?
Civil liability, Judge?
What is the basis of the civil liability?
Because he's alleged to have entered into the apartment. We just want to make sure that there's no allegations of things being stolen and things like that.
Are there allegations of things being stolen?
No, Your Honor.
And I'm not accepting a no contest. That's the case. We can always, everyone can take a no contest plea from now into infinity for potential things that are not even placed into the record. That I don't have a sufficient basis. It's either we can plead to the charge or we can run as exam.
Do you want to run it or do you want to plead?
You can have a moment to talk to him outside.
He says he'll plead.
Do you want more time to talk to your attorney? Is that a yes or no?
Well, tell her she's asking you.
Do you want to talk to her more? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? You gotta use words.
Yes.
Okay, you put your hand down. I have an advice of rights and plea information sheet. It's 2 pages. There's a signature page here. Did you go over this document with your attorney? Sir?
Yes, please.
Okay. Is that your signature?
Yes.
Okay, you understand all the rights that's listed here? And you're willing to give each of these rights up in order to plead guilty to the charge of entry without permission?
Yeah.
Okay, so you have the right to the presumption that you are innocent. So as you stand there, sir, you're innocent until proven guilty, and it's your right to maintain your innocence and require that they prove that you're guilty by first proving each element of the charge being brought against you beyond a reasonable doubt. You understand that? You want to give your right to the presumption of innocence up? Okay, well then let's move forward. You don't have to waive your rights if you don't want to. And you shouldn't waive your rights just to get this over with. You understand that? Are you ready to run an exam?
Yes, Your Honor.
Okay, we'll go off the record real quick while she counsels her client a little further. And then I'll call the case in just a moment. Mr. Etheridge. Mr. Walker. Have you communicated with them? He's in high school, is my understanding.
I believe he is, Your Honor. I'm not 100% sure. I have not had any contact with him. I've tried to email him. He does not have a phone number that he provided us. And I was trying to check. I believe he hadn't checked in with pretrial services, and I forwarded the email to him to check in. Try to verify that. I hopefully it hasn't forwarded. Yes, John, I received an email Monday from pretrial services, Emily Beard, advising that he had not enrolled in pretrial services. They didn't have a phone number for him, asking if I had any contact information. At that time, I emailed Mr. Walker, forwarded the email, have them requesting that he be enrolled or contact him to be enrolled, and advise him to contact pretrial services immediately. Received below email. My understanding still hasn't checked in with pretrial services, but I'm not.
Who else was on this email that you received? The email from pretrial services, who else did they send it to?
Just me, Your Honor. They were trying to get him enrolled before they took any action, giving him the benefit of the doubt.
Yeah, we don't have a number for him either because he said that he had his phone and that he would stay with his grandfather. I think part of his bond conditions was that he was supposed to not have any unexcused absences from Everett, and I don't know if this is what he constituted as an unexcused absence. So I'll hold it for 48 hours. However, it's not likely that you can even get in contact with him. The best that we could do is try to contact Everett High School and have them get a message to call his attorney or check his email.
Yes, Your Honor.
That's the best we could do.
He does have a very favorable plea resolution, so I think that if I can get in contact with him, we can get this resolved.
I would, if I were you, try to call Everett High School and see if they'll deliver a message. I know they won't confirm if he's there or anything on to you, but you can let them know that you represent him in a legal matter and you need him to contact you immediately.
Thank you, Your Honor. I will do that.
I'll hold this until you can make that contact.
Thank you, Your Honor. I'll email the court what response I get regarding that.
Thank you. Okay, and it's 10:01 and Mr. Perone is still not here. Is that correct?
That's my understanding, Your Honor.
Oh, okay. Let's see. What happened to the, oh, so what happened to the civil matters with their goes. Mr. Sark's client's downstairs, correct? Janice and Joan.
That's correct, Your Honor. That's set for 10:30. That's continuation of the preliminary examination.
You on it, you need to put what we, next week ain't gonna help me when I go search your email. Put the dates. You've done that. You were doing the dates and then you just stopped.
Okay.
Mr. Piper is on that one, isn't he? He might be. Is Mr. Piper supposed to be here today?
I'm handling.
Oh,
Piper's
okay.
cases.
I haven't seen Mr. Piper either.
Our office has been in contact with Mr. Perone, so I'm not sure where.
Is Ms. Schroeder, Ms. Robinson ready?
I think I saw her just walk into the courtroom there.
Let me see if I can find my notes. agenda this one. But the witnesses are probably not here yet on Jones, is that what's going on? We have witnesses here on Jones.
I have not.
Right
had
now?
any check-in.
We do not have any more witnesses on Jones, Your Honor, so we would be proceeding to closing arguments on the charges that we can find. Or we will be arguing on some of the charges.
We don't have any witnesses, that's why we adjourned this.
I understand, Your Honor. Unfortunately, I was conducting this last minute. We are waiting for officers, and the officers have since informed me that they are out of the county for the next couple of months for training. So that's
Right,
the issue that
okay,
I'm running
it was
into.
adjourned for,
Correct. So instead of adjourning it again, we'd be binding over on the charges that the witnesses did testify to.
we can bring Jones up.
All right, don't worry about it. I'll come back and get that.
Okay. Are you ready to run an exam?
He would like to plead guilty, Judge.
I don't see anybody for Jeffrey Brown. Is anybody for Jeffrey Brown? Okay, on the record in the matter of case Credit Union versus Jeffrey Allen Brown 21-00909 GC. Counsel, can I have your appearance?
Good morning, Your Honor. Scott Chernich on behalf of Case Credit Union.
Okay, and this matter was scheduled for a hearing on a objection for installment payment order. It was scheduled for 10 o'clock. I don't have anyone present for Jeffrey Allen Brown. And you're objecting to an installment payment order, is that correct?
Well, it's his, essentially, yes, it's his motion for an installment payment order. We objected to that since he's not there and asked the court to deny his motion.
Okay, can you just speak up a little bit? You have a
Sure.
few fans. You say you're objecting, and then what?
No, Mr. Brown brought this motion for an installment payment order. It's his motion. We objected to that.
I understand that, but you're
Yep.
objecting is my, and on what basis are you objecting?
Well, there's a couple of reasons. Essentially, that based on his proposal, there's going to be over 18 years to satisfy this judgment. So that's unacceptable. It's also not even 15% of his take-home pay. And then the third, well, one of the third reasons is that he's asking that the court prohibit, let me just get the exact wording from his motion. He's requesting no property seizures or income tax garnishments, and the statute doesn't allow for that. And lastly, Mr. Brown isn't even there.
Give me just a moment because I can't get into all base. Yeah, I just need you to perfectly do. I'm sorry. It's his motion first on the panel. That should be a flag. Is it visible? Yeah. Two, one. Oh, it is a physical file. And look at it, let me in on base. So there's that. Okay. Why did this come back? It looks like his mail was returned. Okay, I just realized who this was as I'm reading the motion. I don't even know that it's appropriate that City Councilman Jeffrey Allen Brown. And he didn't appear for his motion hearing.
He did not. And I'll just point out to the court that there are no documents whatsoever attached to this motion, nothing to prove what his allegations are, and he's not there.
Okay. I'm gonna have to recuse myself from this case. This is gonna be reset. I'm sorry. Okay, we'll get a new date to you after it's reset, okay?
Thank you.
Thank you. Okay, back on the record, in the matter of Davin Anderson. And you do now want to accept the plea offer and plead guilty?
Yes.
Okay, so you understand your right to be innocent until proven guilty, and you want to waive that right and waive the right to require them to prove your guilt? Can you say that?
Yes.
Okay. Is anyone threatening you to do that? Okay, any promises if you give up that right?
No.
You understand that by giving up that right, it also means that you're gonna give up your right to remain silent at any trial and not have silence be used against you. You're gonna give up your right to see, hear, or question any witness that they intended to call to testify against you. You're gonna give up your right to call your own witnesses or present evidence at trial that you believe show a defense to this charge, and your right to waive your silence and testify at your trial if you'd like. You understand that?
Yes.
And are you currently on probation or on parole?
No.
Okay, you understand that a guilty plea could result in conviction that you may need to report to your current employer, or you need to put this conviction on a future job application. You also could have impact on where you can travel or get immigration status. So you may want to go outside of the country on vacation somewhere, and they may consider this type of conviction something that won't allow you to enter their country. You understand that? As to the amended charge of entry without permission, how do you plead? Is that because you believe you are guilty?
Yes.
Factual basis.
Your Honor, I think that I accidentally gave you the police report. So you have that back.
Okay.
Thank you. Mr. Anderson, on April 8th, 2025, were you in the area of 3200 South Washington Avenue, Lansing, Michigan, County of Ingham, State of Michigan?
Yes.
And did you come into contact with Jeremy Johnson?
Yes.
And at that time, he had physical keys to the apartment. And that was his apartment, correct?
Yes.
And you entered into his apartment and you did not have permission to enter into his apartment, correct?
Correct.
I missed something. He was with who?
The victim in the case, Jeremy Johnson.
While you were with him, he knew, I'm confused. Is that a friend of yours?
Yes.
You all were together
Yes.
and you went to his house?
Yes. I was staying.
You said you were staying there?
Yeah.
How long have you been staying there?
For about a month because they'll, you get,
Well, I don't need to know why. You just been staying, you have been living there for a month?
me, I've been, because I got my own apartment downstairs. So
So you say you have been staying there, staying where? And
my girlfriend is staying
your girlfriend was staying where?
at his house.
Okay, so I'm confused. Did you enter the apartment with him?
No, Your Honor, he's stating that the victim stated that he no longer gave Mr. Anderson permission to go into the apartment. But he still continued to go into the apartment.
He told you couldn't enter the apartment? I can't hear a head nod.
No,
So,
So
No, you don't have to say nothing that's not the truth.
well, I'm not advising him. that.
Oh, okay.
I'm just letting him know that we met without permission.
yeah, I answered without permission.
So you originally had permission, but he said.
He revoked the permission? Did he ever, I'm asking the questions now. You were entering this house regularly prior to this date? Is that a yes?
Yes,
Okay, and your girlfriend was living there, you said?
yes.
Okay, and the owner, the person who possesses the home, what's his name again? Jeremy? Jeremy told you couldn't come into his house anymore?
No, he did not. I had the house key.
You entered with the house key?
Yeah.
Did he ask for his house keys back?
No,
Fails. The plea fails.
Yeah.
Jeremy's here?
yes, Your Honor.
Okay, well then we can have an exam.
Okay.
no. All right, he said I couldn't enter.
When did he tell you that?
He didn't say it.
He did?
Yeah,
Why did you just finish telling me that he didn't, he didn't say that?
I just want to allow.
Because what? Because one of the two was a lie. And I had you swear to tell the truth under the penalty of perjury. So if you just lied under the oath,
No, I do not.
then that means that you're
No, I
subject to the penalty of perjury.
No, I did not lie. I had the house keys. He gave me house keys.
Okay, did he revoke your ability to come into his home? Okay, well then you're gonna have an attempt.
Take it to trial.
As you should. If what you're saying is the truth, then that's what you should do.
No, because I mean, I really don't. I just don't want to go to jail right now.
Who said you were going to jail right now? You're innocent. You don't send innocent people in jail. They have to prove you guilty. And even if they proved you guilty to an entry without permission, there must be some special circumstances before I put you in jail for entry without permission. Maybe probation, but jail, it depends on the circumstances. But if what you're saying on this record under oath, under the penalty of perjury is the truth, they would have to prove beyond a reasonable doubt that what you're saying is not the truth. And at this point, I'm not in a position I can't accept your plea because it's apparent to me, the only reason why you're trying to plead is to get it over with so that you don't go to jail because that's your belief. And not because you're pleading, because you believe you are guilty. That is why I asked that question. You can't enter a plea just to get something over with. It has to be the truth under the penalty of perjury. You understand that? That's in your best interest. That's your right. Let me finish this argument and then we'll call witnesses. Oh, your flashlight's on. Let's see, I have another civil matter. I give you my docket sheet? Can I pass that file over? Here it is. Okay. Okay, on the record. Okay. She can disregard that. Okay, let's see. On the record in the matter of the state of Michigan versus Dennison Jones, 25-01098. Yes.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender, here on behalf of Dennison Jones. Mr. Jones is present at council table. He's standing to my right.
Okay, Mr. Jones, that was scheduled today to continue a examination. And my understanding is that there won't be any additional witnesses, that we're just proceeding to argument for the prosecution, correct?
That is correct, Your Honor. If I could just make a record real briefly. The last time we were here for preliminary examination, my Officer Osentowski, was not present. Unfortunately, as I was handling this case last minute, I did not know the circumstances behind Mr. Osentowski. I have since learned that Mr. Osentowski is currently on training and will be in training out of the county for the next couple of weeks. Therefore, in order to not prolong this preliminary examination any further, the people would not be moving forward on count 3 at this time. And therefore, the people would not be submitting any more witnesses and will be moving forward with closing arguments at this time.
Any witnesses from the defense?
No witnesses, Your Honor. Thank you.
Proceed to argument.
Thank you, Your Honor. Your Honor, we believe that we have met our burden on counts 1, 2, 4, and 5, and we ask that you bind over on these charges. In this case, the defendant was charged in those counts. In count 1 with assault to do great bodily harm less than murder. In count 2 of reckless driving causing serious impairment of a bodily function. Count 4 of assault with a dangerous weapon. And count 5 of assault with a dangerous weapon. In regard to count 1, the elements for this crime for assault with intent to do great bodily harm can be found in Michigan Criminal Jury Instruction 17.7, and there are 3 elements. The first is that the defendant tried to physically injure another person. The second is that at the time of the assault, the defendant had the ability to cause an injury, or at least believed he had the ability. And the third element being that the defendant intended to cause great bodily harm. Your Honor, in regards to this charge, you heard previously from 2 witnesses. One being Nanika Cooney, an eyewitness, as well as Quavatis Jacobs, the alleged victim in this case. They told you both that on February 2nd of 2024, on Malibu Road, City of Lansing, Ingham County, State of Michigan, that there was a road rage incident that resulted in the defendant, who was identified by Ms. Cooney as someone that she had known previously through parties, getting into a fight in the road with Ms. Jacobs' two sons. You then heard that during this fight, the defendant, Mr. Jones, got into his vehicle, started driving at a high rate of speed, and hit both Quavatis Jacobs as well as her son, Jamari Horn, with his vehicle. It is clear off the testimony the defendant tried to physically injure them based off the circumstances. You heard that there was a fight going on between the defendant as well as this family. Additionally, you heard the fact that he took off of a high rate of speed while the two victims were in the middle of the road. Furthermore, Your Honor, you heard that he even turned back around, picked up some friends that he had left behind, he picked up some random item that the witnesses did not know what, and then drive off again afterwards. All of this shows that he had a clear ability that he clearly intended to cause great bodily harm, and he had the ability to do so, as he clearly did based off the testimony you heard from both Ms. Cooney and Ms. Jacobs. Finally, using a motor vehicle shows an intent to not only cause great bodily harm, but speeding in that vehicle also shows that as well. Therefore, we have met the elements for count 1. In regard to count 2, reckless driving causing serious impairment of a bodily function, the elements can be found in Michigan Criminal Jury Instruction 15.17. And once again, there are 3 elements to this charge. The first is that the defendant drove a motor vehicle on a highway or other place open to the public. The second is that the defendant drove the motor vehicle in a willful or wanton disregard for the safety of persons or property. Then willful or wanton regard means more than a simple carelessness, but does not require the proof of intent to cause the harm. The third element is that the defendant operation of the vehicle caused serious impairment of a bodily function to Quavatis Jacobs. Your Honor, in regards to the first element, you heard once again from Ms. Jacobs and Ms. Cooney that the defendant was driving his vehicle on Malibu Drive. This is clearly a road that was open to the public, as both him and Ms. Cooney were driving their vehicles on that road at the time. The second element is clear as well. Once again, you heard from both the witnesses that the defendant started and drove this vehicle on that road at a high rate of speed, while other people, including Ms. Jacobs as well as her son, were on the road. Mr. Jones clearly knew these people were present in the road, as he was just in a fight with them. And he drove at a high rate of speed down that road, showing a willful and wanton disregard for the risks, and ended up hitting Ms. Jacob. And then in regards to element 3, Your Honor, you heard from Ms. Jacobs that she suffered serious impairments of bodily function. She broke both of her legs, she broke her collarbone, she broke her elbow. She stated that she had to get multiple stitches, and that this crash, this hit and run, ultimately resulted in her getting surgery for a knee replacement. It is clear that the elements have been met in regards to count 2. In regards to count 4, Your Honor, assault with a dangerous weapon, the elements for this charge can be found in Michigan Criminal Jury Instruction 17.9. There are 4 elements for this charge. The first is that the defendant either attempted to commit a battery on Quavatis Jacobs or did an act that would cause a reasonable person to fear or apprehend an immediate battery. The second element is that the defendant intended either to injure Quavatis Jacobs or make Quavatis Jacobs reasonably fear an immediate battery. The third element is that at the time the defendant had the ability, appeared to have the ability, or thought he had the ability. And the fourth and final element is that the defendant committed the assault with a dangerous weapon, in this case being an automobile. And as I have already argued, Your Honor, you heard from both witnesses that testified to the fact that the defendant left a fight that he was involved with Ms. Jacobs' son, got into his vehicle that he arrived on scene in, and ran over Ms. Jacobs, who was still on the road at the time, who was trying to step in and stop the fight from occurring. Once again, the circumstances of the fight, the defendant taking off at a high rate of speed, and him coming back to the scene of the crime to pick up friends and leave, show the intentionality of his actions. An automobile is very clearly a dangerous item that can be used to seriously injure or kill an individual, Your Honor. Therefore, we have met this element. Finally, in regards to count 5, assault with a dangerous weapon, once again, the elements are obviously the same. However, the victim in that case would be Jamal Horn. Once again, you heard from both the witnesses in this case, Your Honor, Ms. Jacobs, the mother to Miss Horn, as well as Miss Cooney, that Mr. Horn was hit by the vehicle as well. I ask that you bind over on that element as well. So we believe that we have met all the elements on counts 1, 2, 4, and 5, and we ask that you bind over on the charges of the complaint. Thank you.
Thank you, Your Honor. Respectfully, the defense would disagree with the people's characterizations of the testimony from Ms. Jacobs and Ms. Cooney. Respectfully, the defense would request that these remaining counts, counts 1, 2, 4, and 5, be dismissed for reasons that relate to the prosecutor's inability to solicit testimony as it relates to the specific elements for each of these charges and each of the elements. Further, Your Honor, respectfully, the defense would request a dismissal based on concerns about the credibility of both Ms. Jacobs and Ms. Cooney. It is a very low threshold when it comes to evaluating credibility in the context of preliminary examinations, but still respectfully, Your Honor, neither of the two witnesses were credible enough for the limited purposes when evaluating the elements here as relates to the people's request for bind over. There are too many differences in the story. There is too much confusion over the timeline, over who was possibly driving, and specifically as it relates to count 4, which is Kayvon Horn is the alleged victim in count 4. Neither witness provided sufficient testimony to establish the elements as it relates to Kayvon, nor did Kayvon testify in terms of what his understanding of the situation was. This is a offense that requires an intent element. We never heard from Mr. Horn. We don't know if he was in fear of an imminent battery or fear of an assault. He didn't testify at the preliminary examination. As it relates to count 5 specifically, we never heard from Jamari Horn either. He didn't show up today at the preliminary examination. He didn't testify, so we don't know what his understandings were. We don't know. We don't know. We didn't hear from him if he felt that he was in fear of an imminent battery or an assault or anything else for that matter. We heard from Ms. Cooney. We heard from Ms. Jacobs, and certainly they could speculate as to perhaps what their understanding was of the situation, but respectfully, we didn't hear from either Kayvon or Jamari Horn. And as it relates to counts 1 and counts 2, again, Your Honor, respectfully, neither Ms. Jacobs nor Ms. Cooney were credible enough for the low standards required for a preliminary examination to warrant bind over on these counts. Ms. Jacobs, respectfully, clearly was struggling with her memory. She struggled with identification as it relates to who was the alleged driver at the time. There was apparently quite a chaotic situation. Both her and Ms. Cooney were describing a very chaotic situation where you had multiple people involved, a minimum of 4 or 5 at least. And respectfully, this was at night in early February, February 8th, 2024. So respectfully, Your Honor, the people have not met their burden of proof as it relates to the elements here. There's just too many inconsistencies with the testimony from the only 2 witnesses that did testify, and the defense would request a dismissal on all counts, Your Honor. Thank you.
Can you re-argue?
Yes, Your Honor. I believe that the statements made by both witnesses were very clear and were near identical, Your Honor. That Mr. Jones got into a road rage incident. Mr. Jones was identified by Ms. Cooney. Mr. Jones got into a fight with Ms. Jacobs' children. He got into the vehicle and hit them. That's all very clear, Your Honor. Any question about credibility would be an issue for the jury at this point in time, Your Honor.
Excuse me? Where'd you get that rule from? Isn't the court the sole determiner of credibility at the time of a preliminary examination?
Yes, Your Honor. However, as Mr. Sartz said, that threshold is incredibly low, Your Honor. It's for preliminary
Correct.
examination
But your
purposes.
statement was any question of credibility, that's absolutely incorrect.
And I apologize, Your Honor.
Any other argument?
The only other thing, Your Honor, is I would say in regard to count 4, it does say Quavon Horn. The people based off the testimony would be moving forward on Quavadas Jacobs being the victim in count 4, not
Not
Quavon
Horn.
Horn.
And then count 2, still with Jamal Horn.
Count 2 would be Quavadas Jacobs, Your Honor. Count 2.
Count 5, sorry.
Yes, count 5 would still be Jamare Horn.
So that should be, okay, got it. Okay, you can have a seat.
Thank you.
Okay, let's see. Today was the date scheduled to continue. Today was the date scheduled to continue a preliminary examination. The burden is really upon the prosecution to establish probable cause as to each element of the charges that are being brought against you, the felony charges. It's not a trial. They don't need to prove each element beyond a reasonable doubt. It's just more than mere suspicion that these crimes were alleged. That is a low burden. It's not a very high burden that they need to overcome. But the court, as I just previously indicated, is the sole determiner of any credibility issues of witnesses at the time of the examination. And if the evidence presents a question of facts, then it goes to the jury. In this particular case, we had testimony here from 2 witnesses. Let's see here. There was a Nautica Cooney who testified first, and then Corvatus, I believe is how you pronounce her name, Jacobs, who testified second. Ms. Cooney testified that on or about February 8th, 2024, that she was driving down Waverly in the city of Lansing, Ingham County, making venue in this court appropriate, that she identified the defendant and he was driving a blue Chevrolet Equinox. She said that she was in the vehicle with her boyfriend and 2 children. There was some lane switching that took place. She stated she switched lanes. The defendant braked and honked her horn. So it sounded like she maybe switched lanes right in front of him. Maybe wasn't the best driving, is what he was frustrated. He had to brake for her to switch lanes and honk his horn. And she stated that the defendant then switched lanes to get back in front of her and then applied his brakes. That interaction she described unequivocally. I don't see any reason to discredit her testimony. It sounds just like a road rage incident. It sounds just like she's even describing her driving, because she cut in front of somebody else and he had to brake. And someone who's not being credible likely wouldn't share that piece of information, but that information was shared. And that the defendant then sped up again to make a right on Malibu. She sped up to make a right on Malibu, that is the victim. And that her boyfriend got out of the vehicle and a physical and verbal fight ensued between the person she identified in the court as Denison Jones and the boyfriend, the victim's boyfriend. I'm going to stop right there because, again, credible testimony here. That she is driving, she claims, and she testified that she was familiar, maybe she had saw the defendant someplace hanging out or something prior to, but it doesn't sound like she really knows him or that the boyfriend really knows him. She also testified to having her children in the car and her boyfriend. She's driving obviously to either his family's house or someplace where his mom is and siblings are. And there's no information before this court that leads the court to believe that Mr. Jones needed to be on Malibu at that date, time in question. But we have a scenario that involves a road rage incident and then honking and saying whatever expletive I'm sure he would have said in his car was not sufficient. He now tries to get back in front and brakes. And then when she goes around him to turn, he follows her down Malibu Street, and then obviously gets out of his vehicle for there to be a fight to ensue between her boyfriend and this defendant. And so there was nothing about this testimony that lacked credibility. The statements that the testimony given by this witness differed from the testimony from the second witness is grossly disingenuous because the other witness wasn't even there to tell this portion of the testimony. So this is completely from her vantage point, and there was no other testimony to contradict that testimony. So I find that testimony to be overwhelmingly credible. And then the fight, she states, ensues. The defendant went into the trunk and grabbed a broom. She testified she was not sure who swung first. Not necessarily relevant to the decision that I need to make here today because, again, why would Mr. Jones be outside of his vehicle on Malibu? Except for to engage into an altercation because he's upset that they cut him off. Nonetheless, they are engaging in an altercation. It becomes physical. We don't know who swung first, but we do know, based on her testimony, that Mr. Jones goes and retreats to his vehicle to grab a broom and dustpan and ice scraper. And then the victim, Ms. Cooney, or the witness, Ms. Cooney, testifies that Quaban, Jamari, and Quavitas all arrive outside and walk up to the defendant's vehicle. There were some others, I guess, that ran away because she stated that the defendant began to swing the broom at the parties. She testified that the brothers went to the defendant in front of the defendant's vehicle. The defendant then got into his vehicle and used his vehicle to run over Miss Jacobs, Quavitas Jacobs. Mr. Jones, she said nothing during that time. Quavitas was in front of the vehicle and Quaban was on the side of the vehicle at the time of this. Quavitas was on the side, I guess, waiting for EMT, and the witness, Ms. Cooney, said she could visualize head, knee injuries and maybe an ankle injury and some blood. We then had testimony from Quavitas Jones, who testified that she ran outside after hearing some commotion in front of her home, and that she ended up being hit and knocked unconscious. She believed she was dragged a little bit by the vehicle, and that as a result of being hit by the vehicle, she said that both her legs were broken, her collarbone suffered some injury. There were elbow injuries. She needs a knee replacement. And she stated that she saw her son bleeding on the outside of his leg and blood on his chest. Again, testimony was overwhelmingly credible. She walked outside because of an altercation. She gets hit by a car. Don't even believe that we allowed her to properly identify, but that's why we had Ms. Cooney. She identified who the driver of the vehicle was. So again, the court finds the testimony to be credible. I believe the prosecutor did an excellent job of going over the instructions. I won't belabor the jury instructions in the elements. As to count one, however, assault with intent to do great bodily harm less than murder or by strangulation. Based on the credible testimony and the elements that were met through the testimony, the court is satisfied that there's sufficient probable cause as to count one that will be bound over. Count two is reckless driving causing serious impairment of a bodily function. I think there was a number of incidents in this total scenario that were reckless. Someone cuts you off, you usually honk, but to get back in front of them, if this is true, and then apply your brakes in a way that seems to indicate that you're trying to cause them to have to hit you or whatever you were doing or would have been done, that's reckless. But then to follow them, engage in an accident or altercation, that is, and then when multiple parties are in front of your vehicle, to get inside the vehicle and accelerate and hit people that are in front of your vehicle is clearly reckless driving. We had testimony from Ms. Jacobs that as a result of being hit by the vehicle, that her legs were broken. She needs a knee replacement. And that she had collarbone injury and some elbow injury. As to count 2, there is sufficient evidence on this record to bind over to the circuit court. Count 3 will be dismissed for lack of probable cause. Count 4, assault with a dangerous weapon, that dangerous weapon in this case being a motor vehicle, but there was testimony that there was a broom that was swung and some other items. So there's more than one scenario that could present sufficient probable cause as to assault with a dangerous weapon. Why in the world are we at other people's homes fighting about a traffic incident and introducing a broom, dustpan, and ice scraper is beyond my comprehension, but nonetheless, the vehicle was what is being charged as used as a dangerous weapon. In this case, the testimony was that the defendant accelerated his vehicle in a way that caused injury to Ms. Jacobs. So as to count 4, which is amended to make it assault upon a Corvatus Jacobs, that is sufficiently pled as to probable cause and will be bound over. Count 5 is as to a Jamari, I'm not sure if I'm pronouncing the name correctly, Jamal Horn. And the testimony of the witness, or actually both witnesses, was that Mr. Horn was right on the side of the vehicle when Mr. Jones accelerated and actually hit Miss Jacobs. The court is satisfied that there's sufficient probable cause as to count 5, assault with a dangerous weapon, felonious assault on Jamari Horn. All counts, with exception for count 3, will be bound over to the circuit court. The bind over date is going to be May 28th. That's the date that the circuit court.
Sorry, Your Honor.
That's the date that the circuit court gets the file. This is really information for him because you know this.
Yes.
That's the date for the circuit court to get the file from the district court. Did you hear the bind over date or you want me to repeat it?
Repeat it for me, please.
Yes, it's
Sorry.
May 28th.
Thank you,
Okay,
Your Honor.
you do not have to appear on that date, okay, sir?
Okay. Your Honor.
Thank you, Your Honor.
Okay, let's see. Your next court date will be a pretrial in circuit court. Your attorney will be made aware of that date. He must be being held on something else because he has a PR bond on this. Did you want it amended so that he accrues time?
Your Honor, he's serving sentence respectfully. I would just request the bond be looked at this. Thank you.
He's serving sentence on,
Something unrelated to this case, Your Honor. So he would not be entitled to the credit that because he's serving a
okay,
sentence.
sounds good.
So respectfully, I would request the bond be looked at this. Thank you.
Okay, bond was set at 2,500 personal recognizance with a no contact order as to the alleged victims. That will continue. Any additional matters for the record?
Not from the people, Your Honor. Thank you.
Defense will just be requesting the transcript, Your Honor. Thank you.
Thank you. LVNV Funding LLC versus Lisa Thomas, 23-021. I'm sorry, 01217, council appearance.
Good morning, Your Honor. It's Craig Fay, P 1401 on behalf of plaintiff.
Okay, let's see. That's a physical file. Okay, let's see. Today was the date scheduled for hearing on objection to garnishment. Is Ms. Thomas present? I don't see Ms. Thomas in the courtroom or on the virtual courtroom. Double check. Okay, she filed an objection to garnishment stating that the writ expired and is invalid.
Correct. It's in, at least in her objection, it's indicating that it needed to be served within 91 days, which is incorrect. The garnishment is good for 182 days. So based on the only objection being that defendant indicated that the garnishment must have been served on the garnish sheet within 91 days is invalid. So we just requested the objection to garnishment be denied.
Okay, I do see her attachment. I do agree that the writ is in fact valid. She also has failed to appear. Her objection is denied. You're all set. Thank you.
Perfect. Thank you, Your Honor. Have a good day.
Thank you.
Mr. Smith, sir, they submitted the stipulation order of dismissal on May 6th, and both parties signed. I looked at it on all dates.
That's for both?
For, yeah, Riviera, Senator.
Okay, Ms. Riviera Zuniga?
Yes.
Okay, my understanding is that your matter's already been dismissed.
Yes.
Your Honor, Tim Smith for LAFCU.
Okay, I just need to sign the dismissal. Yeah, it's okay. I just need to sign the dismissal and that will resolve the case. So you're all set for today.
Okay,
Thank
thank
you.
you, Your Honor. Appreciate it.
Thank you. What's going on with the other one?
I tried to write in the chat. He didn't respond, but they did meet.
Okay, this is the matter of LVNV funding versus Markel Miller Nelson 25-01130. Appearance, please.
Good morning, Judge. My name is Ed Mahl, M-A-H-L. My P number is 27115.
Okay, and I see Mr. Markel Miller Nelson.
Yes, Your Honor.
Okay, you're without counsel. Today was the date scheduled for pre-trial for a general civil matter. Did the parties come to a resolution or complete a joint pre-trial statement?
We did not come to a resolution, Your Honor. I think we both would like discovery rights with a chance to file a motion.
Okay, well, that's what the joint pre-trial statement is for. You have to complete a joint pre-trial statement. Did you send the two?
I'm sorry, I did. We probably,
We sent our joint pre-trial statement form to your email address.
okay. And we did not file one, Judge?
You're asking me?
Yeah, I've got the file, but I don't see a joint pretrial statement. Normally this firm would file something like that.
No, we sent you an email in preparation for this pretrial with our standard form to complete a joint pretrial statement with Mr. Miller Nelson. And unless, if you're the attorney handling it, unless you met with him to go over it, I don't know how it would have been completed.
I don't have it, Judge. I didn't go over it with him.
What's your
We just
email
talked-
address?
EDAMAHL@gmail.com.
That's who, the email we sent it to. What date? We sent it today already. We sent that email to, we sent the form to that email today.
You did? All right. Well, I'm on my, can you pass this a moment and I can download it?
We can put you back in the meeting room. I'm going to start a criminal exam in just a moment, as soon as I put you in there.
Okay. Well, thank you.
No problem. We can do that. I just don't know. There's no big thing. On the record in the matter of the state of Michigan versus Eric McClinton, 25-00071. Appearance, please.
Good morning, Your Honor. Randall Berman on behalf of the people. Jacob Braun on behalf of Eric McClinton.
Okay, today was the date scheduled for preliminary examination. How are we proceeding on this?
Thank you, Your Honor. The complaining witnesses failed to appear. I would note for the record that not only myself, but others at my office have tried to reach her, been unable to do so. But without her appearance, we are unable to proceed. I perceive Mr. Perone asking for a dismissal. I simply ask that it be dismissed without prejudice. Thank you.
Has the complaining witness ever appeared?
My knowledge, no. No.
Counsel,
So I make a motion to dismiss on the basis of her non-appearance.
motion to dismiss is granted without prejudice. The people do have the right to reissue this against you, okay? The people have the right to reissue this against you because it's being dismissed without prejudice, okay? Do you have any questions? We'll get you a copy of dismissal in just a moment.
I'm gonna tell it, you guys tell it to
We'll notify them so you can go back to the county and have it removed, okay?
today.
Today.
Thank you.
Thank you, Your Honor. Thank you, Your Honor. Thank you.
Me too. Okay.
Yeah. We want to talk, what?
Look at my mom sending me text messages.
Correct. Yeah.
He wants to talk to somebody. It's more important for me.
I don't know what that's.
That's a great question.
His name is Michael Rowland.
No, he's out there talking.
Yeah. Michael Rowland.
Sure.
So wait for your copy. They left.
Yes, it's okay.
Wait, you're gonna wanna do the second one, no?
Oh,
Just
second
the
one.
top one,
Yeah,
city.
it's. What do you have?
Second one. Correctly.
Yes.
You guys have fun.
Drama. Like you say.
I can fill it out if you want.
Okay. So larceny, you want to do with house.
Yeah.
Restitution for $200 to.
Okay. After he's taking.
Yes, yep.
Where you go? Oh. Yeah, break.
Oh, yeah.
I said, your break is your time to go.
Okay, I'll be right back. All right.
All right, just need your signature. And that also is something I'm gonna have to put your name all over the notes.
I was gonna say, I don't know if you want to talk to the victim before. What does that mean?
Yeah, I guess that's what we'll do.
Perfect. Yes. It's with Natalie, so, yes. Michael.
No. No person. I know. but- No. Yeah. Jeez, goodness.
All right. Okay, ready on your matter, Ms. Robinson?
Yes, Your Honor.
So I mean, I always ask, I don't have an attorney. That was
I don't know where
weird.
it starts when, so.
Oh, okay.
Oh, we're not
What's the
doing
matter?
this.
Just for the transcript.
I'll look around before. Oh, wait.
Did Mr. Arnold get fingerprinted?
No.
Okay, on the record, in the matter of the city of Lansing, I'm sorry, state of Michigan. Let me switch my brain back over. The record of state of Michigan versus Davin Anderson, 25-01067, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Anderson.
Okay, Mr. Anderson was scheduled for preliminary examination today. Are we ready to call in witnesses?
Yes, Your Honor.
Yes, Your Honor. I did just want to make the court aware that the people do intend on adding a count of unarmed robbery at the end of this examination.
Okay, if the elements support that, then we'll deal with your motion at that time.
Got it. Thank you, Your Honor.
We would ask for the rule, Your Honor, as well to be invoked.
You asked for what?
The rule to be invoked of sequestration.
Sequestration is granted. You can call your witnesses.
The people will call Jeremy Johnson.
I don't know if that. Well, you need to confirm that right now.
I am.
Okay. I don't think they're taking it from jail fingerprints. Oh. When people need fingerprints, yeah. Well, how come we don't have his fingerprints? I mean, I didn't send them.
The clerk's office has them, when they get them, sometimes they don't put them in the system.
So you think they're in there?
I'm sorry,
You think the clerk's office has them?
I'm gonna check with Marquita and see if they received them yet.
You can have a seat, sir. You said it's NJS and that.
It's not in JS,
Oh,
but I don't know if it's signed. But it-
Oh.
Here in this chair.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you can have a seat. There's a microphone that's right in front of you. The microphone is so that the court reporter, which is the lady sitting behind you, can take down everything that's being stated in the courtroom. It will not amplify your voice. You need to keep your voice loud and clear, okay? Also, if there's an objection, you will stop speaking immediately. I will make a ruling on the objection, and I'll tell you if you can give us that answer or not. You're not allowed to answer questions with mhm, uh-huhs, or head nods, head shakes, because we cannot understand that on the record. So it needs to be audibly articulated, okay? State your first and last name and spell both.
Jeremy Johnson,
Spell both.
Jeremy Johnson, JOHNSON.
You can see.
Mr. Johnson, where do you live?
I think it's 3200 South Washington.
Can you repeat that, please?
I think it's 3200 South Washington, 3500 South Washington.
Okay, and what apartment?
433.
And is that in the city of Lansing?
Yes, ma'am.
Is it in the county of Ingham?
Yes.
Where are you staying right now?
Right now, I'm not staying at the house. I'm staying somewhere else.
Okay, and can you tell me why you're not staying at your apartment at 3200 Washington?
Just scared to.
You're scared to? Okay. Do you recall the date of April 8th, 2025? That was a yes?
Yes.
And why do you recall that date? Did something significant happen?
Yes.
Okay. Can you tell me a bit about that?
I was told to basically get out of my apartment. I'll come back for a couple of months.
And who told you that?
Right there, the guy right there.
Okay, can you please point to the defendant and describe an article of clothing?
Black shirt.
Okay, thank you. Your Honor, at this time, I would like the record to reflect that the witness has identified the defendant.
Any objection?
No objection.
So noted.
Thank you. Okay, so that day, let's go back to April 8th, 2025. What were the interactions between you and the defendant that day?
What do you mean?
What occurred between you two?
He kicked me out of my apartment.
And how?
He told me to leave, and if I didn't leave, and then someone put me in a coma and jumped me and put me in a coma. And if I called the cops, they'd kill me. That's what he said.
Okay, and did you just leave the apartment and then he entered? Did you have to give him keys? How did that work?
I gave him the keys back after I took them.
Okay,
back.
so and what prompted you to give those keys?
Because I was scared.
You were scared?
Yeah.
Okay, and what made you scared?
Because I owe him money.
Okay. Okay, and did he threaten you?
Yes.
Okay. Did you give him the keys because he threatened you?
Yes.
Okay. Did you want to give
No.
him the keys?
No.
Okay. Did he have permission to go into your apartment at all?
Yes.
When?
At one point in time.
But not on April 8th, 2025?
No.
Okay, so there was no permission for him to enter the apartment
No.
on April 8th, 2025. Okay. And do you know, does the defendant have an apartment in that complex? Why was the defendant there? Do you know?
He lives in that building.
He lives in that building as
Yes.
well. Okay. So at one point, he did have permission to be in your apartment.
Yes.
On the date in question, he did not.
Yeah, he kicked me out my own apartment and told me that I owe him money and that I wasn't to come back to my apartment. And if I did, he would kill me if I called the police. That's what he said to me.
Okay.
Or him and his son will put me in a coma. That's what he told me.
He said he and who?
Him and his son.
Okay.
would jump me and put me in a coma.
So that's why you gave him the keys?
No, that's not why I gave the keys.
So why'd you give him the keys?
Because I owed him money
Okay,
and I was scared when he asked the keys back.
okay, I think I understand the confusion. So are there two sets of keys?
No,
There's one set of keys?
Yeah.
Okay. Did you want to give him those keys?
no, I did not, honestly.
Okay. So then why did you?
I was scared.
You were scared. Okay. So the keys were the keys taken from you? Or did you hand over the keys after, because you were
Hand over the
scared?
keys,
Okay.
yes.
And were you scared for any other reason, or any other reason, or is it the threat?
That's why I was
That you
scared. I
heard.
got like that, so scared.
Okay. One moment, Your Honor. No further questions at this time, Your Honor.
Cross-examination.
All right, Mr. Johnson, you stated before that at one point in time, Mr. Johnson, or excuse me, Mr. Anderson had permission to enter your apartment, correct?
Yes,
And when was that?
that was a couple of nights before, a few days before, actually.
And what sort of arrangement did you guys have?
All right, so everything,
What sort of arrangement did you have? Like, why was he allowed to enter your apartment?
I owed him,
Excuse me?
I owed him money.
Okay, so was there an arrangement between you two?
No,
Like,
wasn't a certain time or nothing like that, no.
so a few days before April 8th is when you gave him permission to enter your apartment?
Yes.
If you could, when you say arrangement, are you talking about arrangement to enter the property or arrangement to pay the money back? Because I'm not clear.
An arrangement to enter the property.
Okay, and you said because you owed him money, you let him enter the property?
Yes, to talk, yes.
You said what, to talk?
Yes.
Okay.
Okay, so when you gave him permission to enter the property a few days before April 8th, what was the nature of you giving him permission? Like, why was he coming over?
Because I owe him money.
I understand that there was a prior sort of, somebody owed you money, but what I'm asking is like, why did he come into your residence? Like, was there an agreement that he would be allowed to stay there with you because he owed you money?
No,
Okay, so then why was he coming into your residence if he just owed you money?
because I was scared, like I said.
But so I'm talking about the few days before April 8th.
Yeah.
When you gave him permission to enter your apartment.
Yeah, just come and hang out.
So you were hanging out?
Yeah.
Okay. And how long have you known Mr. Anderson?
For a couple months.
And did you ever give Mr. Anderson the key to your apartment
Yes,
prior to the April 8th incident?
yes.
When was that?
I'm not sure, 2 days before that. That was just for a couple days while I was gone.
Okay, so you just stated that he was allowed to come over because you guys were hanging out, but then was he allowed to be in your place while you were gone as well?
For that, the first time, yeah, but not at that particular moment, no.
So we're still talking about the few days prior to April 8th. He was staying at your apartment and you were not there, correct?
Yeah, for a couple days, yes.
And this was an agreement the two of you made because you owed him money?
No.
When he was allowed to enter your apartment, was anybody there with him?
There was some lady there.
You said some lady there?
Yeah. It was him.
Did you know who that person was?
Not really.
So on the date of this incident, did you tell him he could no longer stay at your apartment?
Yeah, once he told me, when he kicked me out, he kicked me out of my fucking apartment.
So he kicked.
I was in fear for my life. That's why I left my own apartment, because I was scared for my life.
I understand what your previous testimony is, but my question is that on the 8th, is that when you came back
Yes,
to your
I took
apartment?
Yes, he was sleeping. I took my key from the key fob to try and get him to leave on the 8th, and he would not. He came looking for me. He was pounding on the lady's door looking for me. He grabbed my key back out the hallway because I was in fear at that point, and he took my key from me. Because I don't care if I owe some money, you don't have a right, you don't have an agreement, you're gonna stay at my apartment for a month or 2 months, because I owe you some type of money.
So you came back on the 8th. Did at any point in time when you came back, did you immediately tell him to leave?
Not at first, no.
Okay, and then you're stating that when you came back on the 8th to your apartment, he was there and he told you to leave.
Yes, absolutely, yes.
Was anybody there with him that day?
When he told me to leave, yes,
Who was there with him?
some lady and his kid, I believe.
Just some lady what?
Some lady and his kid.
Some lady and kid was in his apartment, in your apartment?
Yeah, when I came back, yeah.
Okay.
And how long have you stayed in this apartment?
I've been there for about 8 months now, 6 to 8 months.
And 2 months prior to this incident, you guys were friends, you guys were hanging out with each other? But 2 months prior, up to the 2 months prior of April 8th, you guys were considered friends, hanging out?
Prior to the 8th?
Yes.
Yeah, before the 8th, yeah.
So there were no incidents or anything before the 8th?
No.
When you came back to your apartment that day, was anybody with you?
No.
Did he grab the keys from you or did you give him the keys?
He grabbed a piece from me.
So you had them in your hand and you did not give them to him willingly?
What, the 8th? No.
Okay, so he took them from your hand.
The 8th, he made me give them to me in the hallway. He took them back from me when I took them.
I understand that words were said, but did he take them from you or did you give the keys to him?
Gave the keys to him.
Nothing further.
I need some further because I'm very confused. Okay, so you've known him for only a couple months,
Yeah,
but you've lived there for about 8, 9 months?
somewhere around there, yes.
Okay, and somehow or somewhere in between those couple months, you incurred a debt to him?
Yes,
Do you owe him money?
yes.
Why?
Your Honor.
It goes to his credibility.
Okay, I just think there's gonna be an immunity issue. Yeah, can we approach, Your Honor?
Okay, so you know, only known him for a couple months, he has an apartment there?
Yes,
Did someone else live in the apartment with you?
nobody,
Nobody? You're the only person who lived there?
yes.
Okay, do you know his girlfriend?
Not really, no.
Not really, or yes or no?
I don't, yes.
You do know her,
Like, I don't know her name or nothing like that, no.
but you recognize the girl?
Yes.
Okay,
Yes.
she doesn't live with you?
No,
Okay, and so, based on your friendship, you were allowing him to just come hang out?
yes,
Okay, and how many times has he hung out in your apartment prior to April 8th?
just a couple times,
Which couple times? 2?
3 or 4 times for
3 or 4
hours. at a
times?
time, yes,
Prior to April 8th?
yes,
Okay, and in some of those times you were not there?
one of the times,
Okay, so one time he was allowed to be in your apartment and you weren't there, so you gave him the key to get in?
yes, the first time.
Why is he hanging out in your apartment versus his apartment? Do you know?
Are you just hanging out here and there? That's it?
But he lives in the same building.
Yeah.
Like,
Just
what,
come
he
visit.
likes your TV better or?
I don't know, no.
Okay, but he just likes to be in your apartment over yours? Oh, over his? Okay.
Well, I don't know, he's just visiting.
I'm sorry?
He's just visiting.
But how's he visiting if he's there and you're not there?
Yeah.
So what was,
The one time he was there, that was it. He had the permission that one time.
that's how I'm asking. I recognize,
was
I
gone for a couple days. I had to leave and take care of some business.
I get that, but why would he need to be in your apartment if you're not there?
Because I owed him money. And
He needs to be in your apartment because you owe him money? Did he say that to you?
no,
Okay, so in your head, you decided that he needs to be there because you owe him money?
no.
So why did
Because I'm
he,
just fucking scared right now. That's it. That's why. I didn't
Okay,
say
I'm not-
nothing more.
well,
about
why does he
anything.
need to be, so you're gonna be gone, he asked to be in your apartment while you're gone? Yes or no?
Yes,
And so you gave him the key
yes.
and you did that out of fear?
Kind of, sort of, yeah.
Well, it's either yes or no.
I'm just gonna say no.
Okay, so
I'm
you
already
were,
scared enough right now. Yeah.
okay, so you weren't scared at that time?
Nope, sure wasn't.
Okay, and so, but you knew you weren't gonna be there?
Yes,
Did you ask him why he wanted to be there if you're not gonna be there?
no,
Okay, and so then fast forward April 8th, when did he enter your apartment? It was on April 8th?
no.
When did he go into your apartment?
He was in my apartment for a few days while I was gone. I came back on the 8th.
Oh, so the time that you were gone, this is the same one time you allowed him to be there?
Yes,
Okay, then now it's not starting to make sense. So how long were you gone?
I think it was 4 days.
Okay, so maybe around April 4th, you left, he asked for the key or to,
Yeah, well, I give him the key so I can lock the door.
oh, he was already there, you were leaving? Is that what
Yeah,
happened?
yeah.
Okay, so you said I'm leaving, and you asked him to leave then?
On the 8th?
No, on the 4th.
No, I didn't ask him,
Oh,
no.
okay, and so you just gave him the key? Is that, and went on to handle your business for 4 days?
Yeah,
And then you.
I was in the mental facility, is where I went to for 4 days.
Okay, and so you return after 4 days,
On the 8th,
and now he's there with extra people?
yes.
Okay, and did you ask him to leave then?
No, because I was scared.
Okay, however, this is when he was asleep?
Yes, I got into the apartment, yeah.
How did you get in the apartment?
I had maintenance come let me in, the main maintenance guy.
Okay, and so you got.
My door wasn't being answered.
Got it, so you
And I
knocked on the
had
door,
key.
nobody answered, and he has the
maintenance
key,
came,
got
the
it.
guy came, let me in, and he was in there sleeping, I took my key back, while I was sleeping, I took off real quick, tried to avoid all the situation.
Where was the key when you took it?
It was on a key fob, I mean, a key.
Like hanging like a key?
Yeah, like a key hanging thing, yeah.
Like on the wall?
No, like this, like a key thing.
No, I know what a key
Like
fob
this.
is, but where was
Like
it?
this.
Yeah, but where was
On
it?
my
physically?
island.
On the island,
Yes.
okay, in the kitchen?
Yes,
Okay, so you got your keys and then you left,
yes.
and then you said he went looking for
He
you?
came looking for me, pounding on doors.
Okay, and then that's when you had an exchange, and then,
He told me to give him the fucking key back, and that's when I was scared, so I gave him the key back. I went to my apartment probably about few minutes later, because I know what I was gonna do.
so you gave him the key?
Yeah, I was scared at that point, when I gave him the key.
Got
back.
it,
I was
and,
scared.
but then you went back into your apartment? Did he go with you?
I didn't go eventually right into my apartment, he had the key, and he ended up leaving.
But
And
the
I
door
ended
was
up going-
unlocked?
I walked around, figured out, no, my door was not unlocked.
How did you get back in the apartment?
He answered the door.
He was in the apartment.
Listen, when he took the fucking key from me in the hallway,
Why are you swearing in my
because I'm
courtroom?
scared as hell right now,
Why?
because
Why? You're talking to me. I'm asking you a question. You don't, I'm not, did I swear at you?
oh man,
Then
I
don't
wasn't,
swear-
I'm sorry. I was
Then don't
nervous.
swear at me.
I was nervous, sorry.
So he took the key back,
Yes. He
and
ended up
did,
going this way.
and
I
then
was
he
too
went,
scared, so I
did
avoided
he,
him.
did he,
went straight
don't
to my
talk over me.
apartment.
I'm asking questions because I'm trying to paint a picture. And when you were given 2 opportunities to answer questions, it didn't paint a clear enough picture for me.
Yes, ma'am.
So now I'm gonna direct the question.
Yes, ma'am.
So you gave him your key back. Did he then go back to your apartment?
Yes, ma'am.
Okay, and so at some point later, not immediately, you then go to your apartment.
Yeah, I was walking around the hallways contemplating what I was gonna do and how I was gonna go about the situation I got myself into.
Okay,
So I went back to go to talk to him, and that's when he told me that's when his son was there and that lady was there. He told me that basically asked me where his money was, and I told him that I didn't have it. You know, basically what I'm saying, I was basically prolonging the inevitable to him, you know, about money, owing money.
okay,
Basically, because I lied.
Got it.
About them having more money. and I didn't have a lot
okay.
more money.
So it's your belief he's hanging out in your apartment because you owe him money?
Yes,
Okay, and your belief is he's not gonna leave until he gets the money?
that's what he told me.
That's what he told you?
He told me, he picked me up on my apartment, so don't come back here without the money, or me and my son put you in a coma, and if you call the cops, I'll kill you. That's exactly what he said.
Okay, okay,
That word.
That's all questions I have.
okay. Any
I have one-
redirect?
I have one follow-up question, Your Honor. So when you go back into the apartment on the 8th and you get the key from the keychain, the
That
key
morning.
fob that's on
Yes.
the island, okay? When he takes that key back from you, do you physically hand it to him or does he take it off of your person?
I handed it to him because I was scared, because I could see the look in his eye when he asked me for the
Okay,
key.
and what did he say when he asked
He
you?
said, where's the fucking key at? Exactly like I said it.
Okay. And was this before or after the threat to put you in a coma?
That was right before.
Okay.
It was a little
So it
before.
was, okay, got it. So that was all
Yeah, 'cause I
about
was
the
walking
same
around and
exchange?
Yes, ma'am.
Okay, thank you.
I'm gonna have her redirect or recross because of my series of questions, but I just have one more question. When you had whatever transaction led to you owing him money, was there, and I think that's what I asked, what she asked about, was there an agreement as to when you would pay him back?
As far as him staying in my apartment, as far as certain amount of
No,
time I owed-
what was the
Yeah.
agreement? There was an
The
agreement?
agreement that I was gonna be paying him some money that I owed him, yes, ma'am.
When?
And I couldn't pay it back. It was supposed to be a few days after.
Okay, and then you didn't pay it back?
I didn't pay it back. 'cause I
And
didn't
you all
have
had
the money.
another conversation after that? maybe, about where the money was?
I just told him that I didn't have any money, because I lied all about having money.
I get it. Was there ever an agreement that he could stay in your place until you got the money?
No.
Okay. Cross exam.
Why did you owe him money?
Objection, Your Honor. This would be an immunity issue, so we would want the victim here to have an attorney.
You want me to adjourn this so that you can get him an attorney?
Yes.
We can
That's
do
what
that.
we're gonna have to do.
Any other redirect other than that? Or do you want to wait?
I think it's probably gonna have to be best to.
Sounds good. Okay, we'll adjourn it. We'll resubpoena him so that he can be counseled by an attorney. I'm assuming he's gonna request a court-appointed attorney, which means he'll probably need conflict counsel, correct?
Yes, Your Honor.
I'm sorry? Well, it's up to them. If they want to have an attorney or have him testify without an attorney, or he's gonna have to have an attorney so he can be counseled as to the immunity is my assumption. And they can enter an immunity agreement. I don't know how long it's gonna take you to do that. Do you know how long?
I would say at least 3 to 4 weeks, Your Honor, just so we can get conflict counsel, because I know that takes a little bit of time. And I apologize for the record, Bart Buxton on behalf of the people.
Thank you. You do June 27th at 9:30. June 27th at 9:30.
Your Honor?
Yes.
Is there any way that we could do a continuance as opposed to an adjournment? We do have another witness here who can testify, that wouldn't be impacted at all about this.
Absolutely.
Okay.
So, we're continuing his testimony until.
Yes,
then.
Your Honor.
Correct. We can continue.
Okay.
You're all set for today. You'll be resubpoenaed to be back here June 27th,
Yes, ma'am.
okay? Thank you. Also, there's a sequestration order, so you can't talk about any of your testimony with any other witness.
Okay.
Thank you.
Yep.
It's Alexino Wanda, like her last name is. Failing to recall.
Do they have the order?
I called it to.
Sorry. Yeah, you're right. You're right. And then I took this again. Wanda Weber.
Downstairs.
I said.
The people will be calling Wanda Weber, Your Honor.
Thank you. I forgot all about them. Oh, boy. Counsel?
Are you calling
I didn't-
LVN funding?
Correct. I didn't, I didn't know you were still in the breakout room. Did you all complete the joint pretrial statement?
Yes, I filled it out by hand. I faxed him. I emailed him a copy of the statement and we went over it and we filled it out by hand.
Okay.
We can't sign it right now. We're not in the same room. So can we send it to him and have him not, sorry, go ahead.
Mr. Miller Nelson, can you start your video, please? Did you have any questions about the joint pretrial statement, sir?
Not this time, Your Honor, no.
Okay, do you give Mr. Attorney Mall permission to sign your name to it and then I have to review it?
Yeah.
You don't have to. You can request to have it sent to you first, but I'm going to review it. That's why I'm asking you if you have any questions or concerns.
Okay, yeah, I'd make it sent to me. And
Okay,
that was an option.
Sounds good. So he'll send it to you. You need to sign it and get it back to him. And then he'll get it filed with the court so that I can sign and review it. That's what we use to kick out your scheduling order, which would include deadlines for discovery and deadlines to file motions. And then we'll set your trial date based on that, okay? Any additional matters, counsel, today?
No, Your Honor. I think what we'll do is we'll email it to him and then he can sign it and email it back perhaps. I don't know if he has that ability. Okay. All right. Thanks a lot, Judge. Okay, bye-bye.
Have a good one. Bye.
Yeah, you too.
Name the witness again?
Wanda Weber.
Okay. You're Ms. Wanda Weber?
Yes.
You can stand and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. Okay, so there is a microphone that is right there in front of you, and the purpose of that microphone is so the lady behind you can take down everything on a recorded record as to what you're stating here, but it does not amplify your voice, so I need you to have your voice loud and clear because of the temperature. We have about 3 fans running in this courtroom, okay? Okay. And then this kind of drowns out sound sometimes. So if there's a question, that calls for a yes or no, you will answer yes or no. You can't do head nods, head shakes, or mm-hms, uh-huhs, because we can't articulate that in the record. Otherwise, you'll just hear us ask you if that's a yes or a no, okay? Okay. And then if there's an objection, you'll stop speaking. That means I have to make a ruling on the objection, and then I will, based on the evidence rules, tell you if you can give us that answer or not, okay? Okay. I'll state your first and last name and spell both.
My name is Wanda Weber, WandaWeber.
All right. Good morning or afternoon or whatever time it is.
Still morning for 11 minutes.
Still morning, Ms. Weber. Can you tell us what you do for work?
I'm a property manager.
Okay, and what address are you the property manager?
3400 South Washington Avenue, Lansing, Michigan, 48910.
Okay, great. And is that in Ingham County as well?
Yeah.
Okay. Great. And do you recall the date of April 8th, 2025? Do you recall anything significant occurring on that date?
I do.
Okay. Can you tell us a little bit about that?
I was coming into work and I saw somebody standing outside acting a little disoriented. Wasn't quite sure who it was. Don't recall ever seeing that person. It ended up being Jeremy Johnson.
Okay. And did he live in that building?
Yes, he did.
Okay, and how did you find that information out?
Well, when he was acting disoriented, I kind of asked him who he was, told him who I was, and asked if he lived there. He said yes.
Objection, hearsay?
You want to respond to the objection?
Yes, Your Honor. I would argue that this was that this would be an excited utterance. She already testified that he was disoriented.
Okay. I guess if I consider the totality of the circumstances, I'll accept it. Oh, objections overruled.
So you asked him if he lived there?
He said yes. I asked if he needed to be let in because he didn't have a key.
Okay.
He said yes. So then we walk in behind me, he asked if he could speak to me, and I said yes. And at that point, he.
Objection, Judge, I think this goes beyond the excited utterance.
Okay. Well, she can testify, I agree, she can testify to what she did without telling us what he said.
Sure.
Based on, based on the communication from him to me, I called 911.
Okay. And what did you tell 911?
I told 911, I believe that I had a resident that was indicating somebody had taken his key fob from him.
Objection, calls for hearsay.
Your Honor, I'd argue, I'm sorry.
You can respond.
I'd argue that this would be a present sense impression describing the situation that was happening at the time.
Stop being off for the truth of the matter, sir, so the objections overruled.
That. Okay, proceed. What did you tell 911?
What he had shared with me, that somebody had taken his key, he had been doing drugs, that he owed somebody $200, and they wouldn't let him back in his apartment. And so that's what I remember at this point.
Okay, and can you describe his demeanor?
Nervous, afraid, really
Okay.
worried.
Okay. And was he able to get back into his apartment, do you know? Was that the end of your interaction?
No, not at that point. He was not. We had to wait for the police to come.
Okay, and did you do anything further after the police arrived, or did the police take it from there?
The police took it from there. We watched on the camera.
Okay, and are you familiar at all with the defendant in this case?
Yes, I am.
Okay, and how do you know him?
Just saw that he's a resident there. I don't know him personally, but just that he's one of my residents.
Okay, and he's not a resident of this apartment that Jeremy was trying to get
Not of
into,
the same
correct?
apartment, no.
Okay, perfect. So
He's-
totally different apartments.
Correct. He's one of my tenants. They're both one of my tenants, but in different apartments on different floors.
Got it. Thank you. Nothing further at this time, Your Honor.
You stated that when you called 911, that Mr. Johnson reported that he was doing drugs.
Not at that moment, no, that he had in the past and that he owed somebody money for drugs.
You said he appeared worried and disheveled. Can you elaborate on that?
I didn't use the word disheveled. He appeared worried and nervous. That's all. He feared for his life, were his exact words.
Was he sweating?
No.
Did he have any sort of slurred speech?
No.
All right, and as the apartment manager, do you have camera surveillance throughout the complex?
We have 99 cameras with 300 views.
So would that mean that all floors and the outside of all apartments would be covered?
For the most part, yes.
I don't have any further questions.
Nothing. People, Your Honor.
Okay, Ms. Weber, there was a sequestration order, so that simply means you're not allowed to discuss any portions of your testimony with any other witness, okay? You're free to go. Thank you. Thank you. Any other witnesses?
No other witnesses at this time, Your Honor.
We will continue to the June 27th date at 9:30.
Thank you.
Bond will continue. There is a no contact order. You're not to have contact directly or indirectly with Jeremy Johnson. Do you understand that? Okay.
Your Honor, it has come to the people's attention that there has been some witness intimidation issues with both witnesses in this case, so the people just wanted to bring that to the court's attention.
When you say both witnesses, you mean including Ms. Weber?
Yes, Your Honor.
Like what kind of issues? With Ms. Weber at least?
Threats not to testify.
The witness that just left here?
Yes, Your Honor.
As alleging threats against her from this defendant?
Or a third party contact with the defendant.
Got it. Okay. And is there gonna be a police report issued and?
There is not, Your Honor. People just wanted to bring it to the court's attention.
Okay. All right, so Mr. Anderson, this is a peculiar situation only in the effect that you live in the same property that the alleged victim lives in. And then obviously the other witness is the property manager, which means that would be someone that you would likely need to interact with because you live there. You have a maintenance request or rent issue, whatever, you would have to interact with the property manager. So you're not listening, you're trying to respond. And so sorry?
I said, I hear you.
No, I didn't ask you, did you hear? I asked you to listen, because there's a difference. Okay, and so you are not allowed to have any contact with Jeremy Johnson directly or indirectly. That's through a third party or any other mechanism. You can't write a letter. No forms of communication between the two of you. And it looks like it says that you were supposed to be within 2,000 feet. I don't know how they figured that out, how that works. And you're on GPS tether. I don't know how in the world that's working because I've not gotten a single notification that you've been at this address. So we'll look into that because obviously you all live at the same address. Yeah, but the issue, oh, that might be why. You're staying on Davison during this time. Is that correct? That makes sense. Okay. The issue though is that you still hold a lease at 3200 South Washington? Yes or no?
Yes.
Okay. And so it would be really dumb for you to threaten or allow someone else to threaten your property manager unless you want an eviction. Don't you think? On your record, do you think you want to deal with this and be homeless?
I'm already about to be homeless, so I don't want to deal with none of this. To tell you the truth.
I can imagine. Do you want to be sitting in jail while we deal with all of this? Is that a yes or a no?
No, I don't want to be sitting.
Okay, because if I get one more murmuring that there has been some calls to anybody related or connected to this case, that they're being threatened not to appear in court, I can only assume that the only person who would care whether or not they appear in court would be you or someone connected to you. And so I will have to put you in jail or revoke your bond and put you in jail pending a hearing. And then at that hearing, if I find that you are responsible for any threats made to anybody connected to this case, then you're subject to 93 days in jail for violation of the court order. Do you understand that?
Yes.
Okay, so it'll be stupid. Are you stupid? Okay, so then I expect you to act like you're not. And so I expect you to follow the court order. I've not had any violations that you've been at the area of 3200 South Washington, even though you have an apartment there. So it seems like you're compliant in that regard. My hopes is that you would remain compliant and that there won't be any further murmurings of violations of the no contact order or potential witness intimidation threats. You understand that? Okay. Do you have any questions about the order?
No, not about the order.
What do you have a question about?
I'm like, how was?
Is it about the case?
Yeah.
Okay, well, you ask your attorney about the case. They give their testimony. The court makes a determination about whether or not they believe that testimony is credible, or if the testimony amounts to the elements that needs to be met for a probable cause standard. So you don't need to worry about that. You will talk to your attorney about whether or not you're gonna call witnesses to rebut whatever they testify, and including whether or not you're gonna waive your right to silence to testify. But that's up to you and your attorney, okay? Okay, so they're still presenting their case at this point. That's your next court date. Bond will continue, 5,000 personal recognizance. There's a GPS tether and a no contact order protecting the alleged victim. Any additional matters?
Not on behalf of the people, Your Honor.
No, Your Honor, thank you.
You're all set. Thank you.
Yeah.
On the record, in the matter of the state of Michigan versus Micah Arnold, 25-00111. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Stephen A. Freeman, Your Honor, Assistant Public Defender, on behalf of Arnold, who stands to my right. May I please approach?
Yes. Thank you. Okay, so I see here there is an offer for you, Mr. Arnold, to plead guilty to larceny 200 to 1,000. Is that correct?
Yes, Your Honor.
You want to accept it?
Yes, Your Honor.
Raise your right hand. Your other right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Just to put your hand down. I have an advice of rights and plea information sheet. There's two. Is there additional plea offer on the record?
Yes, my apologies, Your Honor. The people would also like to extend HIDA to this defendant.
Okay, no objection to sentencing under HYTA if eligible. You know what that is? So it's the Home Youthful Training Act. You do a term of probation, and if you're successful, this will be a non-public on your record.
Yes, Your Honor.
Okay, so you want to accept that offer? Okay, so again, back to this. This your signature?
Yes.
Okay, you went over these rights with your attorney.
Yes, Your Honor.
You have any questions about these rights? You understand that you have to give up all of these rights if you want to plead guilty to the amended charge? And you're willing to do that? So that means that you will give up your right to be innocent until proven guilty. So as you stand there, you're innocent. And you maintain your innocence until they can prove that you're guilty. Recognize that? And so they prove your guilt by going to trial, and they have to prove each element of the charge that they're bringing, or the charges that they're bringing against you beyond a reasonable doubt. You can maintain your silence. You don't have to do anything by your right, and they can't use that against you. You do have the right to subpoena witnesses that will testify on your behalf to trial, and the right to cross-examine or question any of the witnesses that they call to testify against you. You understand that? And you want to give those rights up? Anyone threatening you to do that? Has there been any promises extended to you if you give up these rights? Are you on probation? Are you on parole? Do you have any other matters pending? Where? You do not have any other court dates pending? Court cases, okay. You understand that by pleading guilty?
Your Honor, Bart Bucks on behalf of the, he does have some cases in circuit court currently.
Okay, sounds like he was a little confused about it. Do you have a matter in circuit court right now?
Yes, June 9th.
Okay, June 9th, what's happening on June 9th? The sentencing?
No. First time in circuit court.
Oh, pre-trial in circuit court? Okay.
Two pre-trials scheduled, Your Honor.
Okay, so you understand that by pleading guilty, that this can result in a conviction, that you may need to report to your current employer, or you may need to put this conviction on a job application.
Yes, ma'am.
It also could have impact on where you can travel or get immigration status. You understand that? Okay. As to the amended charge of larceny, 200 to 1,000, how do you plead? How do you plead? Is that because you believe you're guilty?
Yes, ma'am.
Factual basis, counsel?
Yes, Your Honor, thank you very much. Mike, Mr. Arnold, excuse me, I wanted to draw your attention to October of 2024. Last October, on the first day of October. Do you recall meeting someone in order to sell them a product that you had issued? And when you met with this person, is it true that they had the amount of money that you were requesting?
Yes, ma'am.
And without exacting all the minor details, did you grab that cash that the fella had and run away? And you knew that it was his money and you hadn't earned it or sold anything for it. You stole his $200. Okay. Thank you, guys. Oh, venue. Was that in the city of Lansing County?
Yes. Any questions? Any questions from the prosecution?
The people are satisfied, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea, and I find your plea to be freely, voluntarily, and intelligently made. This matter is set for sentencing July 17th at 9 a.m. When you leave here, you need to go down to the 5th floor to check in with probation so that they can get you set up for your pre-sentence interview. You will have to go through an interview with probation prior to sentencing, okay?
Yes.
Okay, so you're going to check in with them now just to set that up.
Yes.
Okay, so don't forget to follow up, because if you come back and I don't have a report, that doesn't look good. That's not good for you. I usually put people in jail until I can get the report, okay? Do you have any questions? You can appear for your sentencing via Zoom if you'd like. Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing further, Your Honor. Thank you.
You're all set. Notice to appear?
Yes.
We will get you that.
Thank you. A restitution sheet to that file. Working on right now.
Restitution, nothing about restitution on the record.
Okay, so that's any-
We done had a whole record and nothing about restitution happened.
My bad.
Still have that file?
Which one? The last one?
Yes.
Yes.
Restitution, there's a section on this sheet for restitution. Okay, let's see, what's happening? Thank you. Mr. We may die here like the building was on fire.